Welcome to the Festival of Dangerous Ideas podcast. My name is Danielle Harvey and I'm the festival director. Over the coming months, we look forward to sharing with you the audio recordings from the 2022 festival. FODI started in 2009 and is the original Disruptive Ideas Festival. FODI exists to bring to light important conversations that push the boundaries of conventional thought. We all have assumptions of what citizenship means. However, in recent years, we are starting to see the envelope pushed, with more common law rights being taken away. From Australia shutting its doors during the pandemic, to authoritarian regimes acquiring the habit of turning travellers into political prisoners, just where is it becoming too dangerous to go? And if an Australian passport does not protect you, what are you owed by your government? This is the FODI 2022 session, Expendable Australians, with scholar Kylie Moore-Gilbert, author Ian Kemish, and lawyer and research associate Sangeetha Pillai, chaired by journalist Peter Greste.
Welcome to this afternoon's panel discussion on expendable Australians. Before we get underway, I would like to acknowledge the Gadigal people, the traditional owners of the land on which we're meeting. This is, of course, we're continuing a remarkable tradition of storytelling and speaking that runs back over 60,000 years. I'd like to acknowledge the elders past, present and emerging. And before we get underway, of course, the usual housekeeping. If you have your phones, please make sure they're switched to silent. Feel free, of course, to jump on socials and join the conversation, but let's try not to interrupt it with any beeping. So my name is Peter Greste, and I'm the chair for this afternoon's session, and it gives me great honour to introduce this very eminent panel of ours. First of all, we have Dr. Sangeetha Pillai, who's a constitutional lawyer and a senior research associate at the Caldor Centre for International Refugee Law. She's an expert on Australian citizenship law and the scope of government power over citizens and non-citizens. She's also published widely on the topic, and she speaks quite a lot in the media. Then we've got Ian Kemish, who is a distinguished diplomat with a 25-year career. Ian served as a High Commissioner to Papua New Guinea. He's the ambassador to Germany. And crucially for today's discussion, Ian ran the consular service of DFAT from 2000 to 2005, I think it was, before becoming a special advisor, an international advisor to the Prime Minister. Ian has a wonderful book called The Consul, and you can pick up a copy of that afterwards. The Consul really charts Ian's work in the consular service or as a diplomat over that period. And finally, we've got Kylie Moore-Gilbert, an extraordinary scholar of Islamic and Middle East studies. Kylie speaks a whole bunch of languages from the region. She was, of course, most famously detained in Iran in September of 2018 on espionage charges. She was eventually imprisoned and released in November 2020, I think it was, Kylie, in a prisoner exchange arrangement. I am a professor, but more commonly known, better known perhaps, as one of Australia's more prominent convicted terrorists. Between the spy and the terrorist, we've got half a conversation here already. So this is really about, as we've already heard, expendable Australians. This is a conversation about the value of an Australian passport. There are all sorts of situations in which this issue arises. Kylie and mine is one of the more prominent, or a couple of the more prominent examples that we've seen in recent years, but of course there are Australian ISIS brides, ISIS fighters, the children of those relationships that have been stuck abroad. There's the situation of Australians who were shut out of the country during the COVID crisis. There are the likes of Julian Assange, who has been held on very controversial charges for many, many years. So what can we expect of the government? What value is an Australian passport? What are the responsibilities of government when you're stuck overseas? I guess the first question, the obvious person to be answering that question, is Ian.
Thanks, Peter. Great to be with you all. What's an Australian passport worth? It gives you membership of a society that has a certain set of expectations about what the government will do if you encounter serious difficulty overseas. What does that look like? I can tell you what it looks like on a daily basis. I'm going to give you some figures from 2019, which was the last year before COVID really curtailed travel. So what it means on a daily basis is about 3 Australians being arrested every 24 hours abroad, about 5 dying overseas every 24 hours, about the same number being hospitalised that come to the attention of the consular service. So there is a professional service available to support Australians when they encounter that kind of difficulty. We can find fault, all sorts of faults, with the system, the policy that underpins it, but a quick word for the people who do this work. These are people whom our fellow Australians turn to at what is often the most difficult moments in their lives. So this work is happening all the time. It's also a group of people who step forward, and this is available to us as Australians, at moments of great crisis.
But Ian, is the responsibility of government clear? Are those boundaries, what government can and should be doing, clear? Is it written in the Constitution? Is it written in law? Is there a...
There are no laws to govern this. There are no well, there's one, and I think I'll come to it. I'm sitting next to the real expert, but I'll try and say something about the legal situation as well. There are no legal obligations that the government has to Australians when they're outside Australia's borders, other than one, I believe, and this is one where you'll really need to come in, Sangeetha, and that is the right of return, the right of abode. Otherwise, it's a matter of policy, and our government has policies which reflect broadly what we as Australians expect our government to have. Now, I happen to think that in the case of what I believe is a fundamental right, that right of return, that right of abode, we have drifted a bit in a few cases in the last few years, and you've already mentioned some of them, but I'm sure we're going to get into it.
We'll come to that in a minute, but Sangeetha, how does that make your job as someone who often deals with these cases?
Well, I did my PhD on citizenship and I finished it in 2015, and the day I found out that I passed, the government introduced citizenship stripping legislation. And so I've been talking about it ever since. And when I first started this PhD, I was told things like, what are you doing? Like, everything about citizenship has been said, there's no conversation to have here, and that's not what we think when we think about citizenship now. And so I think what we've seen, and it kind of ties in with what you were saying, Ian, is we have these assumptions of what citizenship is. They have, over the course of, you know, the 100 odd years that we've had the Australian Constitution, those expectations have been more or less adhered to for most of that time, and now we're starting to see a pushing of the envelope, so locking out of people or taking away of citizenship, and we have all these interesting questions come up about, is that constitutional, is it legal? And the short answer is we don't really know, because there are arguments, like, you know, the right of return is a fundamental common law right, the right of abode, the right of a citizen to come to their country. It's a fundamental common law right, it's a fundamental international law right, but all of those things cave to the constitutional framework that we've set up, and we have a really open question about the extent to which those rights are reflected constitutionally, and we haven't had the opportunity to really have that litigated before a court.
Does that mean that there's politically useful wiggle room in there?
Yeah, and I mean, again, to come back to what you were saying earlier, Ian, like, some countries do legislate for consular services, we don't, and like the justification for that is that it provides useful wiggle room, like not setting a standard means that there's more flexibility, and that can be a really, I don't think there's a right answer to kind of what the best approach is in terms of legislating or not legislating, but useful, I suppose the dark side of useful flexibility is flexibility to not meet a minimum standard. And
yeah, and for the government to make choices that are based on politics rather than on what the rights of an individual really should be.
Yeah.
Kylie, your case was a very specific case. Did you feel as though you got the support that you deserved from the Australian government?
That's a really difficult question, Peter. I would say overall that I am very grateful to the Australian government, including to the Consular Service, for all that they did for me whilst I was in prison. At the end of the day, the government pulled off this extremely complex trilateral diplomatic deal which saw me freed 2 years and 3 months into my 10-year sentence. And for that, I give them full credit. And that involved various mechanisms and agencies and arms of government, from intelligence to DFAT and the political class as well, and ambassadors in various other countries too. So, they really did step up for me, and for that I'm really grateful. But of course I can also identify areas where perhaps they could have acted more swiftly, with less bureaucracy, less red tape, perhaps communicated to my family a little bit better, and maybe got me out quicker than they did.
I mean, there's been a long, and you and I have had this discussion, in fact we've talked about it, the three of us, the level, or the way that DFAT tends to operate is, they use this term which we hear quite a lot, quiet diplomacy, which suggests that they want to keep any publicity at a minimum to allow the diplomats to operate. But you've been very critical of that. I know I've been critical of that as well. Just tell us about why you think that's the wrong approach.
I don't think it's the wrong approach in every case. And on these tricky arbitrary detention cases, of which we have a handful right now in Australia, of Aussies detained abroad right now who are considered to be arbitrarily detained or wrongfully detained, I think it's a real case-by-case thing. We can't have a blanket rule, whether that blanket rule be only quiet diplomacy or whether it be no quiet diplomacy. I think you can certainly make a case, for example, when a non-state actor, like a terror group, for instance, takes somebody hostage, that having some sort of public campaign for that person could just benefit their captors and maybe even endanger them whilst they're in captivity. But when you're dealing with a state hostage taking, like in my case, the Islamic Republic of Iran, we've seen examples in Myanmar, in China, we've got a chap, Robert Pether, in Iraq at the moment, where it's a state-to-state relations diplomacy issue. I think there's much less logic in a quiet diplomacy argument. The media and campaigning can be actually used as a tool in the arsenal of government to try and get something or to communicate something that perhaps would be more difficult to communicate or to attain in a quiet fashion. And that includes also putting pressure on our government to do something too, because diplomats and bureaucrats, and often it's one in the same, unfortunately, can hide behind the secrecy and this quiet diplomacy argument to disguise the fact that they're not doing enough.
Yeah, I sometimes think it's about giving them the political muscle that they need to make it politically useful, politically valuable to get involved in these cases. Before I'm going to come to you in a second, but one of the things that I didn't realise this, but Kylie, before this evening's session, we were talking about some of these cases, and you mentioned the case of someone who I had never heard about, another prisoner who you met, or who was a neighbour of yours in Iran, who you came across here back home. Can you just tell us a little bit about her case?
I don't really want to go into the specifics of her case, but we do have more Australians who are wrongfully detained abroad than we're aware of publicly. Some of these people, I know of several cases which have never been reported in the media, and we don't actually know how many Australians are arbitrarily detained or are hostages abroad at any one time, because that data isn't publicly made available. And I don't even know if the government knows how many. I think they might be surprised when some of these people pop up from time to time as well, especially if they're dual nationals, if they're citizens also of the country which has illegally detained them or unjustly detained them, or a non-state actor for that matter. So, sometimes these people appear, and in this particular case that Peter's referring to, this fellow prisoner who was also an Australian, came back into my life recently in Melbourne, and I had no idea she was out of captivity. So keeping sort of tabs on how many cases we're talking about and tailoring an approach to each and every one of them, I think, is a real challenge.
When Kylie was talking about publicity, you drew in a fairly deep breath. I know what you're going to say, which is why I'm coming to you on this case. You would have been, when you were running the consular service, you would have been the one who would have been making some of the policy decisions about whether to engage and encourage publicity or not. What was your attitude then, and what is it now?
It wasn't such a deep breath, because Kylie and I have spoken about this quite a few times. Look, just quickly for context, at any given time there are between 300 or 400 Australians imprisoned overseas, long term. I'm not counting daily arrests, they tend to get processed quite quickly. So 300 or 400, I've got to tell you, not all of them are innocent. Many of them are facing justice for things they've done. And we have to be really careful here, because we shouldn't be so disrespectful of the sovereignty of other countries that we feel that our view about the justice or otherwise should prevail over the cultural attributes or the laws of the country concerned. In the end, being an Australian doesn't get you a get out of jail free card. But there are sometimes these cases, and I'm kind of glad I'm part of a society that works like this. There are sometimes these cases, and two of them are represented personally on the stage today, where it just offends our sense of natural national justice, where it just looks wrong, and we expect our government to do something else about them. Now, first of all, I'm glad that I come from a country where people do try. We can find fault in how they do it, and this question of, getting back to the nub of your question, this question of how public you go, I think is a hard case. I've said to both of you before that I can think of two examples from both ends of the spectrum where, in one case, a public, international campaign worked really well, and that was your case, Peter. I think you're the golden boy, if I can put it that way.
My mother would disagree, but
for a genuinely successful international campaign, people working together in a really smart way. And I can think of a case at the other end of the spectrum, and her name's Schapelle Corby, where the xenophobic media campaign, I'm sure, did her no good at all. And there are judgments to be made about these cases in between. Kylie makes a very persuasive, intelligent case about her own situation. I once belonged to DFAT, and I understand a little bit the reserve that people sometimes feel, particularly if the intelligence agencies are engaged. I do think, and I do accept, that there can sometimes be a slightly defensive motivation behind trying to keep things quiet. In the end, though, I think people believe that they are pursuing an approach which will be effective.
Do you accept then that there are times when noisy publicity, the right kind of noisy publicity, is helpful in negotiations with foreign governments?
Yeah, I do. And if I can just briefly tell you a story of a case I was involved in, I was the lead negotiator who managed to get two people out of jail back in 2001 from Laos. It's a case most people have forgotten about now, and it doesn't really matter the detail. But I remember thinking then that the very sort of strong public campaign by family set us back, that we caused in this case, Lao authorities to dig in, entrench, get defensive, and that it prolonged the case. I'm less sure about that now, because I think to myself, would we have worked quite so hard? Would we have been out there? Would I have been sent as a special envoy had this not been a matter of serious public interest? Had it not been something that the Prime Minister and the Foreign Minister at the time were talking about? I'm not so sure. So my thinking has evolved. All I can say is this is difficult territory.
Before we move on, Kylie, you and I were discussing this earlier. Do you think there is a kind of baseline of best practice? Are there any other countries that do this right that we could be following, that set a model for us?
I think it's difficult to identify one country that does it right, because even countries that are doing it differently from Australia, of which there are many, there are a lot of issues with that. I think this is an emerging area, arbitrary detention in particular. What I have myself called for is for Australia to adopt a model similar to that of the US. Not that the US is necessarily best practice model, but they are doing things differently to us, and it does in some areas, particularly communication with families, for instance, seem to be working better. They have a special presidential envoy for hostage affairs, SPEHA it's called, and this is an office of an envoy who sits outside of the consular servers, outside of the State Department or DFAT, and reports directly to the Secretary of State, i.e. the Foreign Minister. And they're empowered and given the tools they need to think outside the box and think differently about arbitrary detention and hostage cases, as opposed to, you know, Ian said 5 people a day are arrested, I think, in every 24-hour period. So you've got literally thousands upon thousands of consular cases that DFAT has to grapple with on a daily basis, separating arbitrary and wrongful detention out from, you know, the huge hullabaloo of, you know, you must have so much going on in the background at all times within DFAT consular, separating those wrongful arrest cases out, and obviously a determination needs to be made. Is this a wrongful arrest case or not? Sometimes it's clear cut, sometimes it's a grey area. And having a separate office, an envoy, or for want of a better word, even a task force, some sort of position or office just tasked with dealing with these issues and also communicating with the families and thinking about how do we negotiate to bring this person home? What can we do that's going to strengthen our hand in any negotiation? How can we engage with our allies, other countries who might have to grapple with a similar thing and have, you know, a similar experience? And really thinking about it differently from, you know, any manner of people who get drunk and fall off their scooter in Bali, you know, on any one day. I think that's, you know, really needed, and Australia would really benefit from having a similar envoy role to what the US has right now.
Ian, one of the things that you spoke of earlier on was the right of abode, the right to return. Of course, during COVID, what we saw was the government shut the borders really tight, and there were thousands of Australians, literally thousands, probably tens of thousands, that were stranded overseas, particularly in India. Sangeetha, was that the right policy? Was that something that was legally sound?
It's an interesting question because it falls into that territory of we don't exactly know, which I brought up earlier. This was an example of, I think this was an example where Australia, in my view, could have done more to try to bring people home, and was like out of step with what a lot of other countries did for their citizens. And I think, at least in part, that comes down to not having clear legal rights that attach to citizenship, which gave a lot of flexibility to the government. And what the government did in the case of closing the borders in general, and in the case of the India travel ban in particular, which locked people who had been in India out of citizens who had been in India within 14 days of this ban coming into effect from coming back home. It relied on this very, very broad piece of legislation, which basically gave the health minister the power to make any determination in the interest of maintaining public health in the context of a public health emergency. And they used this power to the nth degree. They said there's a risk, and so we're going to lock people out. And in other countries that had citizenship rights written down, there was more of an active weighting of what is proportionate. It doesn't mean that everybody got to come home immediately because there were the complexities of a pandemic, but it meant that the government was required to justify what it was doing more. And in terms of that question of was it legal? Well, we had a legal challenge run by a guy called Newman, who was stuck in India, to this law that locked Australian citizens who had been in India out from returning. And there were 2 parts of that legal challenge. The first was, did locking people out fall within what was written in the Biosecurity Act? And the second was, is the Biosecurity Act constitutional? And the courts only got to hearing the first question because the right of abode question, which was the second constitutional question, was a lot more complex. And so there was a federal court hearing where Newman lost. The court found that what the government had done in this case was within the scope of the Biosecurity Act, but the broader constitutional challenge to the validity of the Biosecurity Act and whether there was a right of abode that citizens have constitutionally never got litigated because the ban was only in effect for a short period of time and there simply wasn't time to take it to the High Court. So we have that big unknown. It's very possible that there is an argument that there are strong conceptual arguments that we have a constitutional right of abode, but we've never had the opportunity to test them.
Ian?
Irrespective of the legalities, it was wrong, and I think that's what it boils down to. If I might just say something about that whole time, the period of the pandemic, where we differed from other countries was in the stringency of our border controls back in Australia. I have a lot of sympathy for, first of all, the people who were caught out there. My daughter was one of them, but I also frankly have a lot of sympathy for the consular people who were squeezed between government decision making back home and this extraordinary group of Australians who are out there. We suddenly realised how many Australians were out there. 600,000 plus people came back from abroad to Australia in the course of less than 12 months because their government asked them to. And to be fair, DFAT organised for 20,000 plus of the more, of Australians in more challenged situations to come home themselves, including through their own flights. And you had consular officers who were out there getting COVID long before vaccines were available with their families and all the rest of it. So, there's another perspective on this. But the decisions we made at home affected these people, and in this particular case we're talking about, where Australians in India, well, effectively it became a criminal offence to try and return to your own country. That was just wrong, and the public called the government out on it. The other thing I noticed at the time, which I thought was really interesting, was that a lot of very senior Australians, including ministers of the Crown, didn't seem to have quite caught up with what Australia is today, because people would refer to these people as Indians, Indians who were stranded temporarily in India. These people were Australians, and in many cases they're Australians who've given up their Indian citizenship because they had to.
There was an element of racism in the running through that. I mean, that's the way it felt, or at least politically opportunistic racism.
I just think I'd prefer to put it this way, that I just think we got a glimpse briefly there that senior people in government hadn't kept up with the evolution of Australian society.
There is another group of people who've been stranded, who I mentioned in my introduction, who I guess perhaps in a lot of respects really fit the definition of today's title, and that as expendable Australians. And I'm thinking of the ISIS, the brides, or ISIS fighters themselves, if we want to include those, but particularly the brides of ISIS fighters and the children, many, probably most of whom had absolutely no say in the decision to go to Iraq and Syria. The government has been very, very strident in stripping out the citizenship of a lot of them and in refusing the right of return. Sangeetha, again, let me talk to you. What do you think about that? Is the government justified in saying, look, there's a security issue here, we've got a primary responsibility to protect Australians?
No. I don't give my opinion easily, but my opinion on this is a very, very strident no. And I say that because I did my PhD on citizenship on a project that was about Australia's anti-terror laws and kind of 10 years after September 11. And it was the kind of project looked at the evolution of anti-terror law in Australia and how many laws we'd put into place, how well adapted those laws were to ongoing circumstances many years after 9/11. And we've gone from, in 2001, when September 11 terrorist attacks happened, we had no anti-terror laws on the book, and now we have 92. It's I think it's the most in the world, and a lot of these laws overlap. And so citizenship stripping got introduced in 2015. It wasn't used for, like there's other laws that were in place before that. There's orders that can temporarily exclude people from Australia. There's passport cancellation powers. There's a very, very robust criminal law infrastructure in Australia that kicks in very early. You can be at some of the convictions that we've seen coming out of that are when people are at the very preparatory stage of having a phone conversation where nothing has really happened, and very, very harsh penalties kick in. And so in kind of the case for citizenship stripping being really useful on security grounds in the context of all of this other legislation has not been well made. And I think the consequence, when we think about security, it's not just what can happen in Australia, it's also, it's a global issue. And the consequence of taking away someone's citizenship when they're, and this isn't an Australian example, but there would be examples like this here, the case of Shamima Begum in the UK, who was stripped of her citizenship and was in a position where she was saying, I want to come home. I know that I'm going to face trial when I come home. I know that I might be convicted. I know I might go to prison, but I want to come home and be accountable. Stripping a person in those circumstances of their citizenship potentially leaves them trapped in a terror cell, in a radicalised environment, which is a global security risk.
But the concern has always been that they pose a threat to Australia, and surely that trumps all of these other issues.
You could, I really appreciate that argument, but when you've got someone that's already on the radar of authorities, where you have something that we've got to, and that's where the robust criminal law infrastructure kicks in. The people that are on the government's radar because they pose a security risk are going to have things that they can be charged with if they were here. They're not going to come home and be at loose in the community. If they genuinely pose any kind of risk, they're going to come home, they're going to be tried, and if there's any substance to it, they're going to go to prison for a very long time.
Ian, are our security systems good enough to manage that, to deal with people who may pose a risk if we bring them back to Australia?
If they're not, they should be. We're a wealthy country and we have the resources, and we need to step into this. We have done in the past. This has not been black and white. We've repatriated Australian citizens who we judge to be a serious security risk several times now. As far as I can make out, as far as I can recall, Sangeetha, they've all been cases where there was no other nationality on which these individuals could fall. I'm just thinking there were. I write about this in my book. There were 5 notable cases who came out of the woodwork way back in 2001 in the wake of the American-led offensive in Afghanistan. People remember the names Hicks and Habib, but there were a bunch of others, including a woman called Rabia Hutchinson, who presented herself. Extraordinary story, but she presented herself with her kids and her grandkids at the embassy in Iran, had been married to a senior figure of Al-Qaeda. I remember broadly the discussions around that case, and in the end, right of return trumped everything else, and she came home with a whole bunch of attendant security. And then there's all the other resources. You've got to be serious about this. I mean, you can't just bring them back. You do need to think carefully about de-radicalisation, including the kids. But in the end, if they're Australians, we have a responsibility.
But the problem is, of course, we've got a robust intelligence system, we've got robust rule of law here, but you can't always gather the evidence to demonstrate that people, to know and understand what people have been up to and whether or not to assess whether or not they actually pose a risk. And there is a serious danger, is there not, that people, once they enter the judicial system, can't be prosecuted because we cannot prove beyond reasonable doubt. We can't meet those standards, and that they could find themselves back in the community in a way that threatens the rest of the country.
Well, many would argue that's exactly what's happened with those 5 cases that I was talking about. But what's the alternative, as Sangeetha says? Do you leave them out there, the responsibility of others that are nowhere near as well as resourced as we are to manage these situations?
Kylie, you've seen a lot of Islamists who've studied Islam. I mean, do you see that this is something we should be concerned about?
Definitely. I think there's obviously legal arguments which have been made, but there's also moral arguments. I don't think all people that we've identified as having some association with international terrorism are equal. If we look at the people who have had their citizenship stripped or have been blocked from returning to Australia, who are currently in the camps in Syria right now, for instance. We have the foreign fighters themselves, which are predominantly male. Some of them are in Syrian prisons or etc. We have so-called, ISIS or jihadi brides, or often actually women who've been trafficked against their will into some of these territories by family members, by husbands, even as minors, by parents who then, came of age and were married off to someone against their will. And then we have the offspring of those people. Now, obviously, the children are a no-brainer. Children are not responsible for their parents' actions. If these poor children are born in a war zone and grow up in a refugee camp in Syria and they're Australian citizens, I think we have a moral duty to bring them home. And the earlier, the better, from a de-radicalisation perspective, obviously, too. The women, I guess, they kind of sit in the middle. Did they have any hand in the atrocities that ISIS or Al-Qaeda has been committing in the region or not, or were they also victims? And that's very difficult to determine, particularly as today, obviously all of them would say that they're innocent and they were taken against their will. Some of them probably were, some of them probably weren't. I don't think the case for stripping them of their citizenship on a moral level is there. I think morally we have to bring these people home and, see if there is evidence against them, and if there is, then prosecute them here in Australia. But I do also appreciate Peter's point that we're talking about, messy conflicts in places like Syria and Iraq or even Afghanistan. How are we going to collect that evidence? Sometimes the evidence isn't there, and yet we have a strong hunch the person is guilty. Then we have to weigh that up with, and this goes to the third group of people, which is the fighters themselves, those who have survived these conflicts, who are Australian citizens. What risk are they going to pose to society if and when we bring them back, especially if we don't have enough evidence to convict them on? In that instance, I'm probably a bit more hardline than the others who sit on this stage, and I think if there is any chance that they're going to come back, continue to be radicalised, continue to want to harm the Australian population, we need to weigh up the rights of us as citizens living here in Australia with their rights as individuals. And if they're going to pose an undue danger to us, perhaps we shouldn't let them come back. So I'm very much in favour of bringing the women and children back, unless, on a case-by-case basis, obviously, but I think it's shameful that they've been left there to rot in Syria, for more than a decade now, some of them. Some of those children were born in those camps and, have almost come of age, having known nothing else than, some horrific Syrian refugee camp. But the ones who have been directly implicated in violence, and let's be honest, treason. I mean, they're fighting against the Australian nation and the Australian people for a terror organisation like ISIS and committing horrific abuses, against their own wives and children as well. I don't really know, if we can't convict them when we bring them back, I don't want them back.
Ian?
I guess my additional point is it has been done, and this is possible. It really is a matter of government. The
United States does
judgment.
it a lot, doesn't it?
And we've done it too. The people didn't notice terribly, but in 2019 we actually brought a number of these children. In one case, one of the children had her own child shortly after she crossed the border into Iraq. But yeah, I know the people who executed this operation. It was an all-female consular team, and they brought home a bunch of kids in 2019. The cases that did come to public attention were the children of Khalid Sharoof. You might recall the grandmother, Nettleton, 60 Minutes show. It was out there at the time. It was done, and I believe in those cases a decision was made that these were different because in these cases there was no other nationality. Because the previous government took this approach, as Sangeetha's described, of stripping nationality and pushing it off.
We're going to come to audience questions in a moment. I believe there are two microphones to the left and right, and perhaps if anyone who is interested in asking a question may start moving towards the microphones. But before we do, I'm going to deal with one question which I suspect is going to come up at some point anyway, and that's Julian Assange. Ian, is he expendable?
How do you answer that? No, he's not expendable. Of course, he's not expendable. Look, I'll give you a full view about Julian Assange. I'll start by telling you enough's enough, and he this thing's got to stop. I'm there, right? I personally have travelled some distance on this case. My view will not fit with everybody in the audience. I'm somebody who's come out of the national security establishment. As it turns out, I'm mentioned in WikiLeaks. I was reminded recently. It was pretty innocuous thing. It was me and a bunch of people trying to convince the Americans to go easier on China back in 2001, I think it was. But I actually believe that government officials need to be able to exchange views in a robust way behind closed doors without being exposed completely to the public, because I think that's how you make good policy. So, I personally struggle to see the exposure of all of that as journalism. So I'll tell you that, but I also am conscious, as many others in this room will be, of what was exposed, and some of it we needed to know about it because it was wrong. So I feel a bit divided at that point. I think that we do need to remember that Julian Assange's, some of his period of imprisonment was self-imposed, but honestly this has gone on long enough, and there is a judgment that the United States could make not to pursue this, and I expect that the Australian government is on that case.
I'm sure that both Sangeetha and Kylie will have views on this, but I'm going to move to audience questions, and we may end up picking this up. Mr. Ricketson.
I've got an observation to make. I should introduce myself as the third spy in the auditorium. Kylie and Peter are not the only spies. I've also spent 15 months in a Cambodian prison charged with spying. I'd like to pick up on the point that Kylie made about there being some special envoy. In my own experience, it was clear a few days after I was arrested that on charges of spying that I could not possibly be a spy. And it seemed to me then that more attention could have been paid to my case than if I'd been picked up smoking dope or breaking some obvious crime. Again, in my case, there was no arrest warrant. Various Cambodian laws were breached in the process of charging me. And if the consulate, if DFAT had just monitored what was going on, if they just asked a simple question like, was Mr. Ricketson arrested in accordance with a Cambodian arrest warrant, that question alone, I think, probably would have resulted in my being released within a week of my arrest. The DFAT did not monitor or take any interest at all in my case until publicity, a lot of publicity, including an article by Peter Greste, 130,000 signatures. It was only then that the Australian government took an interest. But anyhow, I guess my point is, because I don't want to rattle on, is that I think that for people who are arbitrarily detained, for people who are clearly not spies, or very possibly are not spies, there needs to be some treatment provided to them that is different to that provided to...
Yeah. And I think that's what Kylie's point was too, yes, about talking about
yes.
an envoy to take over. Yes.
In support of that, yeah.
Yes. Do we have any other questions? I can't believe that. This audience? No? All right, well, okay, sir.
I have no such fame to claim, but... and I'm a new Australian. I also have been supporting Amnesty International. And there are actually many people in prisons around the world who probably shouldn't be in prison. And the question is, do we have a bigger moral responsibility for those who have an Australian passport versus those who have all sorts of other passports but are unfortunately in jail?
Does anyone want to volunteer to answer that question? Sangeetha, you seem to be... We'll come to you. I'll give you a chance in a moment. Sangeetha?
I don't think it, my personal view is, I don't think that there's a question of there being a greater moral obligation to people who are Australian. It's just that we only have, like in Australia, only have power to do anything about people who are Australian. And so, like, I mean, if you go back to the kind of concept of citizenship when it emerged, and it's a flawed concept, like, you know, it's a flawed concept in that it doesn't capture everybody. You know, there are people that have multiple citizenships, and there's the implications of that, and the relationships. There's people that have no citizenship at all and are left at kind of the mercy of a lot of things. And I would say that we have a moral obligation to kind of take account of the humanity of all of these people as a global society. But the way that we structure things in terms of state-citizen relationships, Australia can only do something meaningful for its own citizens in terms of incarceration.
Ian, do you have anything to add?
Yeah, I do. I actually just remember listening to you, Peter Greste, on the ABC not that long ago. It was within the last year when, I've clean forgotten the name of the American journalist who was released from Myanmar. You were interviewed at the time.
Yes.
Danny Fenster.
Danny Fenster,
Thank
yes.
you. And a comment you made was, look, this is words to the effect, much better put by Peter, words to the effect that, you know, a thing to celebrate, a wonderful thing, but let's think of those Myanmarese in there who don't have a foreign government rooting for them. And yeah, we can, as I said before, we can have differences of view about how effective it is, but gee, it's good to have somebody who's on your side.
Sir.
I was one of the many Australians that were caught up overseas during COVID. And my case wasn't as tragic as some who were denied access to partners and loved ones and dying members of the family and these types of things where they had to go through some decision-making via DFAT, and maybe you could talk about what that process was exactly, because there was a lot of ambiguity around how people were able to return to Australia because we were unable to effectively administer a quarantine facility, and therefore hundreds of thousands of Australians couldn't return at their own discretion. And what was shocking, and there were people that couldn't afford to stay overseas for various reasons. They had visa issues, they couldn't return. And what was shocking to me was a complete lack of recourse. That there was no sort of, like, if you've got an issue with your phone bill, you know, you can go to an ombudsman. But there was no real recourse. So there's a lot of very angry Australians that had no means to actually escalate the thing, and there didn't seem to be any real advocacy either. So I just asked if you could speak to that.
I was going to say, yeah, in fact, that raises the question of due process, because a lot of this stuff, because it's extrajudicial, because it's outside of our borders, Sangeetha, doesn't it mean that due process somehow kind of falls away, that you don't have that opportunity to argue this stuff out in court?
The problem is that, like, you know, we have, and I think it comes back to the impact of not having like citizenship rights in law here, in contrast to a lot of other countries. There's a lot of circumstances where, like, you know, it doesn't necessarily matter whether we write rights down or not, but in this kind of emergency situation, what we created was a situation of unbridled government power and nothing in terms of individual rights, and that didn't force the government to take accountability. And so other countries that did have like kind of clearly legislated for or constitutionalised for citizenship rights, when citizens ran into similar issues getting home, there was a requirement. Sometimes it went to court, and courts assessed the proportionality of what governments had done. Sometimes it didn't even get to court because the existence of a legal right meant that a culture developed where the government was proactive and it took steps to bring citizens home, whereas here we had just the government effectively saying, well, it's dangerous, so, and we don't owe people anything, we're not forced to give people anything, so we'll lock them out. And you have very reasonable questions like, well, maybe in March 2020 that was a reasonable answer, but a year into that, why haven't you built a quarantine facility that is functional? Why haven't you taken steps to mitigate things? And like, if we had a citizen's right that was clear, then that might have come out in court because the government would have had to justify whether its actions were proportionate or not. But it's not the system we had. We had the government gets to assess what the risk is, and it gets to take whatever action it deems appropriate in response to that risk. So there's no one holding them accountable, and it's a deficient process, I would say, but it doesn't come up in due process in terms of law because the statutory system that we've set up gives them so much discretion.
So I just wanted to make one point that whilst I was overseas, I was still required to pay Australian tax. So it does beg the question, what's an Australian citizenship actually worth?
Madam.
Hi. I immigrated and have always felt very privileged once I became a citizen to be a dual citizen. I felt that was really something extra. And it's only been in recent years that I've realized that having a second citizenship, in fact, makes me a little more expendable. And I wondered, from your point of view, if any of you would like to comment on the fact that we now seem to differentiate among our citizens here, if there's sort of tiers of good citizens, and also if for other migrants you would recommend we gave up our citizenship if we see our future in Australia. Thanks.
All right, I'm going to invite Kylie to at least have a stab at this, because you're dual British Australian national.
That's true, yeah.
Did that help you, do you think, or did it make it harder?
It didn't really have any impact on my situation at all. I was just taken to a payphone randomly in prison one day and told, okay, UK Embassy or Australian Embassy, which one are you calling? Pick right now. But I do know in the case of people detained in Iran, if the person is an Iranian citizen as well as a citizen of Australia or Britain or wherever, it is a much more complicated mess to get that person out, and it also allows the foreign government a pass to just deflect and say, well, that's an internal Iranian domestic matter. And we've seen this in, cases of Australians who are citizens of foreign countries. In that particular foreign country, they get into trouble, and either because of that country's domestic law. For instance, Iran doesn't actually recognise dual citizenship. It says if you're ethnically Iranian, you're an Iranian, full stop. And it's much harder for the Australian government, say, to go in and try and help that person. So it is sort of it is more difficult if you get into trouble in the second country of your citizenship for the first country to help you out.
And that's the case of Chang Lei in China, isn't it? She's
not Chinese. She's only Australian.
That's true, but she's ethnically Chinese and the Chinese take a view about her.
But legally speaking, we owe her, we must help her because that is her only citizenship.
Yeah, no, absolutely, I agree. The point I'm trying to make is that it's not really about whether Australia deprioritises somebody because of a second nationality. It's your own point. It's about the judgment that the other country will make. And in this case, and that's the only point I'm making, yes, you're right. I agree. Cheng Lei is only Australian. That's not how the Chinese see it.
But that in the case of the ISIS fighters and ISIS brides, if they have a second nationality, then Australia has the power to and often has stripped them of their nationality, of Australian nationality.
So, although footnote to that, but yeah, I think the citizenship was, the concept of citizenship was based on every person having one nationality, and since then dual citizenships emerged, and it's something that in many ways we haven't taken account of. Well, and that risk of what happens if you have dual citizenship, which in many cases is a benefit because it gives you more flexibility, has for decades had that lingering problem of if you get stuck in the wrong circumstance in the wrong place, dual citizenship can end up working against you. What you're talking about just now is what we've had in Australia is a move recently to make the division between sole citizens and dual citizens more explicit in our laws. So dual citizens are vulnerable to losing their Australian citizenship in certain circumstances where sole Australian citizens aren't, even if they pose the same security risk. And the problem, the example that you're talking about someone where they're a sole Australian citizen but are regarded as Chinese by the Chinese government, that happens with us too. We stripped a guy of his... because dual citizenship's messy and it's hard to know where people fit, countries make judgments about what they think people have, and we stripped a guy called Neil Prakash of his Australian citizenship on the basis that he was a Fijian citizen, and Fiji turned around and said, no, he's not. And then you've got, and he didn't care to come back, so it never ended up going to a court, but people get lost in the cracks of something all the time.
Okay, we're actually at time. I'm going to give you two gentlemen a chance, but please, I'll ask you to make your questions very brief and direct. So.
Okay, I'll try to be as brief as I can. So I actually hold 3 citizenship, one of them being Australian, another one being Russian. And you talked quite extensively about the right of return of ISIS fighters, so I would just like to present an interesting conundrum. So I might have a completely legitimate reason to visit Russia at the moment, and while being there, through forced mobilization, I might end up fighting in a war that I feel is pretty condemned by the society and the government, the Australian government. And what would be my right of return in that case?
Do you want to answer that, or do we leave that as a rhetorical question?
I couldn't hear it very well, so...
I think if I can characterise what you're a dual Russian Australian. If you go back to Russia, there is a good chance that you could be drafted into the war, and as a result, be seen by the Australian government as a kind of enemy combatant. Is that broadly it?
That's correct. Yes.
Yeah, I mean, well, it's an interesting question because we've for many years had a provision that provides for people to lose their Australian citizenship if they fight for a government that's at war with Australia. Russia's not at war with Australia, but like there isn't that question about like we haven't really addressed the question. There've been no cases on this, but we haven't really addressed the question of what happens if people are drafted against their will. Like it presumes that people do that intentionally, and yeah, I mean there's a lot of questions in the law as we have it about like, yeah, where people choose to be. It's a very legitimate point.
Please don't go into Russia just now. It's far too complex.
I wasn't going to.
So,
incredibly quickly, I follow the case of my friend and former colleague Sean Turnell, currently incarcerated in Myanmar. This is a case of an Australian who could be seen as being involved in the political environment of essentially another country. How can we manage, or how can we help Sean to return to this country, even though he has been or could be construed to have been involved in the political environment of that country?
I'm going to say I think this is a particularly egregious case because I think Sean's situation has complicated the diplomatic relations and Australia's diplomatic response to Myanmar. For those of you who don't know, Sean was an economics advisor to Aung San Suu Kyi before the coup, which I think took place, was it last year or the year before? The recent coup anyway, and he's been in prison for a very long time. Ian, I think this really is one for you.
Yeah, you remember I was talking before about these cases that just are plain wrong. They're no-brainers. Sean Turnell's a great example. I mean, it's just wrong. His crime was to work with Aung San Suu Kyi, to work with the previous regime.
The argument is that he was working for the country, for the people.
That's right. He was. I knew of his work. I don't know him personally, like you do, but I know of his work, and yeah, absolutely, he was quite committed to the development effort in Myanmar. Look, I don't know what's happening with that case. I am really quite confident, because I know the people concerned, that this is being worked hard. But I just can't answer the how. I don't actually believe, and this is often said in the media, that somehow relations with the regime in Myanmar are somehow trumping management of that case. I don't really accept that. I don't think that's how it works. It certainly has never worked like that in my observation or experience of it over however many decades. But I can't tell you how it's being managed. I fully expect that a lot of effort's going into it right now.
Ladies and gentlemen, I'm afraid that's all we have time for. Before we do go, I am going to say, and forgive me, I mentioned earlier Ian's wonderful book, The Consul, which is available and he will be signing. Kylie's book is The Uncaged Sky, another extraordinarily compelling read. Kylie will be dutifully autographing these, I believe, as well. And for those who are Suckers for Punishment, I've actually got 2 books. Freeing Peter, which is my family's story, and this one, The First Casualty, is my own account, not just of my time in prison, but also on the war on journalism. Ladies and gentlemen, please join me in thanking our wonderful panel, Kylie Moore-Gilbert, Kemish and Sangeetha Pillai. Thank you.
The Festival of Dangerous Ideas is presented by the Ethics Centre. The Ethics Centre delivers programs and experiences designed to bring ethics to the centre of our life. We offer counselling for individuals, leadership and development services, events, courses and educational resources. As a non-profit charity, we rely heavily on donations and memberships. Please visit the Ethics Centre website to find out more. Thank you.